deception. Mr. Glidden, how do you plead this morning, sir? All right. You have just pleaded guilty to a felony, and so I need to ask you a series of very important questions with regards to your constitutional rights, and I need you to answer out loud to each and every question that I ask you. Do you understand that? All right. First and foremost, do you understand, Mr. Glidden, that you do not have to plead guilty to this felony charge this morning, that you have an absolute right to a trial, either by a judge or a jury if you had wanted a jury trial? Do you understand that right?
Yes, ma'am.
Do you also understand that if you had decided to have a jury trial, you would have chosen 12 members of the public to sit on that jury, along with your lawyer, and the lawyer for the state of Maine would have participated in choosing those 12 people. Those folks would then be asked to decide whether or not the state has overcome your presumption of innocence and proven beyond a reasonable doubt, Mr. Glidden, that you are in fact guilty. You would have begun that trial with a presumption of innocence, and that presumption would have stayed with you throughout the entire matter. Do you understand that?
Yes, ma'am.
All right. And again, it's the state's burden of proof to overcome that presumption and convince each and every member of that jury that you are in fact guilty beyond a reasonable doubt. Only if the state of Maine were able to do that could you have been convicted. Do you understand?
Yes, ma'am.
All right. And so for purposes of your conversations with your lawyer, you have reviewed with your counsel the elements involved in theft by deception. Do you understand?
Yes, ma'am.
All right. And so if you were to have had a trial, the state would have had to have proven that you, Mr. Glidden, did commit theft pursuant to a scheme or course of conduct by obtaining or exercising control over the property of the persons listed in the separate appendix, which you have reviewed, and that you had the intention, let me back up, that the theft would have involved property consisting of money with an aggregate value of more than $10,000, and that you had the intention to deprive the persons identified on that appendix of those funds or property, and as a result, that you intentionally created the impression that you had the capacity to complete construction, renovation and repair work for the persons listed in the appendix in accordance with their contracts, and that that impression was in fact false, and that you, Tony Glidden, did not believe it to be true, and that all of those allegations are in fact a violation of a specific statutory section referenced in the indictment. And you understand that that is what would have been proven by the state beyond a reasonable doubt in order for you to be convicted, sir.
Yes, ma'am.
Okay. All right, you understand that the maximum amount of incarceration that you can face having pleaded guilty to a Class B crime is 10 years in prison.
Yes, ma'am.
If you had requested a trial, that trial would have been public. It would have occurred within a reasonable amount of time following your arraignment. You would have had the opportunity to cross-examine all of the state's witnesses, to challenge all of the state's evidence, and you would have also had the right to present any and all evidence or witnesses for purposes of your defense. You would have had the absolute right to remain silent throughout that entire trial if you had elected to do so, and that could not have been used against you in any way. Do you understand that?
Yes, ma'am.
You also would have had the right to testify if you had decided to testify at that trial. Do you understand?
Yes, ma'am.
All right. If you had had a trial and you were convicted, Mr. Glidden, you would have had the right to appeal your conviction to the Maine Supreme Judicial Court. Do you understand that?
Yes, ma'am.
All right. And you also would have had the right to have your sentence reviewed if in fact you were sentenced following that trial for a period of time longer than 1 year. Do you understand that?
Yes, ma'am.
All right. So at this point in time, I appreciate that the request is being made that the sentencing be continued out, but there is a fully negotiated resolution that's going to be proposed to the court at that later date and time. Is that correct?
That's correct.
And why don't we establish for the record what that joint recommendation is going to be?
Yes, thank you, Your Honor. It'd be 7 years with all but 3 years suspended, 3 years of probation, with the following conditions: that he pay restitution in the amount of $1,000 per month to the total amount of $115,000, $275,000 to the various victims that are in attachment A, that he forfeit his $5,000 bail immediately for restitution, that he participate in substance use disorder treatment to the satisfaction of probation and parole, that he participate in gambling addiction treatment to the satisfaction of parole, that he have random search and testing for drugs and alcohol, that he not use or possess drugs and alcohol, that he have no contact with the victims that are listed in attachment A, as well as two other victims which I'll provide to the court at that time, which is the result of the bail violation, that he not solicit, manage, and or possess customer funds, enter into contracts with customers, and that he not work for Olivia Gordon or a business in which he has an ownership or financial interest.
Okay. And counsel, let me confirm with you, again, we're not completing the sentencing today, but that will be your expectation at such time as the sentencing is complete.
It is, Your Honor.
All right. All right, so Mr. Glidden, do you understand that you're giving up all the trial rights that I've just gone over with you, sir?
Yes, Your Honor.
And other than the negotiations that may have taken place between your lawyer and the district attorney's office, has anybody made any promises to you about what will happen upon pleading guilty? Has anybody coerced you in any manner to plead guilty or otherwise placed pressure upon you to plead guilty this
No,
morning?
no, Your Honor.
All right, Mr. Glidden, are you pleading guilty this morning as a matter of your own free will?
Yes, Your Honor.
And are you pleading guilty, sir, because you are in fact guilty?
Yes, Your
All right, Mr. Glidden, have you had enough time to speak about the indictment, your options, the discovery and information with your lawyer?
Honor.
Are you satisfied with the advice and assistance that your counsel has provided with you,
Yes,
to you, I should say? All right, and has your counsel done everything that you expected of her?
Yes, Your Honor.
Do you have any complaints that you feel need to be addressed whatsoever with regards to your representation and defense? Mr. Glidden, have you had anything alcoholic to drink in the past 24 hours? Have you taken any drugs or medications during that period? Is there anything going on with you whatsoever this morning, whether it's physical or emotional, that makes it difficult for you to think clearly, sir? And are you confused about what's happening right now? Where were you born, Mr. Glidden? Waterville, Maine? All right, at this point in time, I'm going to ask the prosecutor to recite a summary of the evidence that they would have expected to present if we had in fact had a trial. When she is finished, I will ask you and your counsel if there's anything that she states that you disagree with, so I would ask that you listen very carefully, sir. And counsel, whenever you're ready.
Thank you, Your Honor. If this matter would go to trial, the state would present witnesses and evidence, including all of the individuals listed in attachment A of the indictment, to show the following: that from on or about September 3rd, 2020 through September 6th, 2021, Tony Glidden was doing business as mainly roofing and siding, in that he defrauded 20 customers, 14 of those over 60 years of age, and of the 14, 8 over 70 years of age. By taking deposits for construction services that he knew he could not complete and or did not intend to complete, he immediately cashed checks, diverted electronic deposits, and used the money as his own, and no work was done for any of the listed victims in the indictment. In total, he defrauded the 20 customers of $115,275. State documents would show that Tony Glidden was the owner-operator of the mainly roofing and siding, which is registered with the Maine Department of State Bureau of Corporations on June 15th of 2020. The Better Business Bureau website reflects that it was opened on February 29th, 2020. Glidden established a Facebook page for mainly roofing and siding, as well as a web page which advertised online estimates, senior discounts, full insurance coverage, boasted that the company had over 500 customers and not a single complaint yet, a Google rating of 5.0, 21 reviews, and a Better Bureau rating of A+ with 0 complaints. The victims in this case all contacted Tony Glidden by telephone, in person, or through the business website requesting estimates and consultations. During 2020, Glidden had at least 2 different business managers who would meet with customers and give estimates. Tony Glidden personally interacted with customers, gave estimates, signed estimates, and accepted payments. And sometime after the fall of 2020, he signed all the estimates and contracts as the 2 managers had quit. It is unknown how many actual employees were working for him, as he regularly posted messages looking for employees, told at least one victim he had 3 crews he was trying to keep busy for the winter, and complained to customers about a worker shortage. According to business manager Corey DeVoe, who later quit, subcontractors from out of state soon refused to continue working when the supplies were unavailable at the job sites. Maine tax records show as of December 23rd, 2021, there's no indication that a 2020 taxes were filed on behalf of the company or by Tony Glidden individually. Testimony from the victims would show that, as well as employees and documents would show that Glidden had used an app called Joist. It was an internet online construction management program. The app allows contractors to draft estimates, change orders, collect deposits, and other funds. The estimates that were used by Glidden, which he also uses contracts, were not compliant with Maine law. The estimates typically do not contain an estimated date of commencement of work, estimated date of the work being completed. The deposits were well above the 1/3 of the total price that Maine law requires. The estimates were missing warranty statements, change orders, residential installation disclosures, and a notice about the Attorney General's publicly accessible website. The victims listed in attachment A would testify that Glidden or one of his business managers would provide an estimate to the customer on one of these documents. If an agreement was reached on price, Glidden would request a deposit from the customer, and the customer would either be required to pay online through the Joyce app, which is PayPal, WePal, or Venmo, or by check. Customers who wish to pay by check were directed to make the checks out directly to Tony Glidden. Victim bank records would show that all the checks were deposited or cashed immediately by Tony Glidden, usually at the customer's bank. Doing that immediately gave Glidden access to cash. In most cases, the customers were told the deposits would be used for materials. Some were told that the deposits were so they could get on his list. On average, the customers were told their project would be started in 4 to 6 weeks, and then he began a pattern of delay and excuses. Glidden did not start any of the listed victims' projects, did not order or pay for the materials as promised, and provided excuse after excuse why he could not begin. He often would tell the customers the materials were ordered, but then months later would indicate the materials had not been ordered. When the victims requested a refund of their deposits, Glidden would refuse, relying on his contracts, which specified that deposits were non-refundable. In fact, bank records and testimony from employees in construction companies, such as Hammond Lumber and McCormick Building Supply, would show he had little ability to make refunds as he had spent the money. Voluminous emails, text messages provided by the victims that would be used as evidence would show that his excuses were overlapping, often conflicting between customers, and included but not limiting to a few of the following: weather, manpower, theft of equipment, death of an employee, theft by his employees. A lending company stole his money. He had no money to buy materials until he paid off the debt so he could get a loan. Another customer had not paid him. He had COVID. His worker stole his truck. He was behind with projects. He fell off a roof and broke his wrist. He got in over his head and messed up by hiring the wrong guys. As soon as he was off job sites, things went downhill. He had $30,000 stolen from him, and it crippled him to the point he didn't work for the last few weeks before he couldn't afford material, and that the police were forcing him to do other jobs. Testimony from employees of the business at the time would show that even at the best of times, mainly roofing and siding operations were chaotic. According to interviews with Cassidy Bridges, Corey DeVoe, Joseph McManus, all former employees, they were not always being paid. Tony Glidden was often not at job sites. Drugs were used by the employees at the site. Joseph McManus, a former manager would testify that he had arranged many of the jobs during a short time with Glidden. He left when he realized the jobs were not being done. He would testify that he had several discussions with Glidden about completing the jobs as promised, but he did not make any headway with Glidden. He found out that Glidden was abusing drugs. McManus chose to leave as he was trying to stay out of legal trouble, and he believed Glidden was committing crimes. Testimony from Corey DeVoe, who was hired by Glidden and replaced Joseph McManus, would show that DeVoe worked for Glidden for 3 to 4 months. He noticed right away that there were issues with Glidden's work crew and that they appeared to be on drugs or strung out when they showed up to work. Glidden would often not be at work in the morning and would call with excuses. Glidden admitted to DeVoe that he was abusing drugs and needed to go to rehab. Glidden also told DeVoe that he was gambling online. DeVoe would testify that he had only been paid about a quarter of what he should have been paid, and that Glidden borrowed money from him on a regular basis to help him make payroll. DeVoe would tell you that after witnessing 4 other customers get ripped off, in his words, and observing what he believed to be drug paraphernalia at the business office, he quit. The Attorney General's Office did a financial investigation on Mr. Glidden. Key bank records were obtained when an account number appeared on one of the victim's checks and the deposit that actually went into an account. Those records would show that an account was opened by Glidden on January 6th of 2021. There were $10,621.21 in cash and electronic deposits made in January, and $9,014 in withdrawals. In February, there was $28,281 in deposits and $30,306 in withdrawals. In fact, KeyBank filed a CRT, or a currency transaction report, on March 1st, reporting the $10,000 and $15 deposits of cash made on one day on February 16th, 2021. Most of the transactions were made by ATM or electronically, multiple ones on the same day. There were multiple purchases made at cryptocurrency sites, daily electronic transfers, and what appeared to be electronic gambling sites. This account was used until the end of February when it had a negative balance. The State of Maine Credit Union business, also discovered in the same manner, was opened on April 5th, 2021 for mainly roofing and siding in conjunction with a loan application. Bank records were shown that on April 5th, 2021, Glidden received what appears to be a PPP loan funded for $8,500, which was deposited into the business savings account. Most of the money was transferred from the business savings account to the checking account and was liquidated rapidly. A review of the record shows several customer deposits from April until June of 2022, which is after his arrest on a felony theft involving Beverly McGill, who's here in the courtroom today. After deposit, the money was quickly liquidated by many cash withdrawals, gambling site payments, and personal expenses. Relevant to this indictment and to the victims, the following checks were deposited into this new business account and almost immediately liquidated, leaving no money for the customer's projects. On April 23rd, 21, Joan Glass, $7,000. On April 26, 2001, Keith Thompson, $5,500. And on June 1st, 2021, Nicole Gatsby, $11,000. Testimony from Hammond Lumber and McCormick Building Supply business managers, employees, would show that Gilden left a pile of unpaid invoices with the local building supply companies. McCormick Building Supply had extended credit to Glidden in July of 2020 for up to $20,000. By December, McCormick closed that line of credit. Glidden owed them over $20,000, but that debt was written off by the company. Hammond Lumber Company sued Glidden in 2021 to recover well over $40,000 of unpaid bills. In November of 2020, Hammond Lumber had extended credit to Glidden at the recommendation of their former employee, Corey DeVoe. By December of 2020, Hammond shut down the credit, placed construction liens on some of the other customers where he had actually completed work, who had had their work completed, but they were later lifted when Hammond Lumber realized what was going on. Glidden had not paid for those materials. The following victim testimonies briefly would be representative of the course of conduct and pattern of behavior, though every single one of them would testify and plan on being here for sentencing. I'm just going to represent a few to the court. Again, Beverly McGill, she's seated in the third row. She's now 84, almost 85.
I'll be 85.
85.
Soon.
She was 83 at the time that this happened. She was retired. She was newly widowed. She would testify that in March of 2021, she lived in Belgrade. She had hired Tony Glidden to replace windows and siding on her home. Her husband had recently died and she wanted to renovate the house with money they had saved over the years. On September 1st, 2020, Ms. McGill obtained a written quote from the company represented at the time by Joe McManus. The quote was for $39,930 for the complete job. As directed by Glidden, McManus requested, and he would say reluctantly when he testifies, a $25,000 deposit to pay for the materials, which is roughly 63% of the total cost of the job. The estimate indicated that installation would take approximately 5 days, and that once ordered, the windows would arrive in about 4 weeks. Written on the estimate was, you gave us the $25,000 deposit to purchase materials. The remaining balance is included in the payment schedule, above which states $8,000 due at the halfway point, which would be when the house is prepped for siding. Thanks for your business. We cannot wait to see your dream complete. Mrs. McGill wrote a check for $25,000 payable to Tony Glidden at his request on September 24th, 2020. The check was endorsed by Glidden and immediately cashed. She received an email from Glidden that same day which read, "Hi Beverly, Tony Glidden here, owner of Mainly Roofing and Siding. Just wanted to let you know I've received the deposit check and it's safe with me. We'll be depositing it into account, and as soon as the funds are available, 4 to 6 days for a check that big, I will go and order all the windows and siding. And then I'll get a date of arrival by next week's end, and we will go from there, okay? I'm going to scoot you ahead of some other people as you were a big job. Thanks, Tony." No work was ever done.
With the support of her adult children, Mrs. McGill sent and received many emails to Glidden from September until March. Only at her insistence and with the help of the new manager, Corey DeVoe, were her windows ordered in November, but Glidden never paid for them. Glidden responded to her emails with many excuses, including blaming his manager, making multiple promises of start dates, which always fell through. Corey DeVoe would testify that he had many conversations with Glidden about Mrs. McGill and told Glidden he had to make it right. DeVoe told law enforcement would testify that Glidden was stringing her along. Glidden asked DeVoe to retrieve a $10,000 deposit check from another customer to resolve the McGill project so that the windows could be purchased. DeVoe retrieved the check, but the money was not used to purchase the windows. Most concerning to Ms. McGill was an email she received from Glidden on February 10th of 2021 that the state believes is evidence of his intent and his inability to do the work and his knowledge of that at the time. Hi Beverly, I am only human and I'm willing to own up for my mistakes when I'm in the wrong. Last fall I was slammed beyond slammed. The guys I had were stealing from me and doing terrible work and it cost me thousands. When it came time to buy your windows, I was going to be wiped out if I paid for the windows. I wouldn't have been able to pay my help or any bills. So I had a loan company tell me if I paid off my $8,000 debt, they would loan me $100,000. Stressing that they would be putting me out of business if they didn't come through, it took the last of my money. Well, they ended up screwing me, and here I am needing to do $300,000 in jobs, and I'm hurting financially. I would never not do the work and plan on figuring this out. I just wanted to tell you the truth because I feel terrible. I'm working on a plan. We're doing a few shingle jobs now, but I can't afford 4 crews, and that's why I'm falling behind. Mrs. McGill threatened to go to the police. He begged her not to and said that his daughters wouldn't have a father at home if he went to jail. He said he would get a loan, that he had money stolen, and on and on. Mrs. McGill felt guilty. She also felt embarrassed that she had, in her opinion, been scammed out of her money, that she reported the crime to the police anyway. When law enforcement interviewed Glidden, he stated that he'd been emailing Ms. McGill about the job, but she was not responding. He was arrested by the Kennebec Sheriff's Department for a theft by deception warrant out of the Kennebec DA's office, Class B. On the way to the jail, he was nodding off. He admitted to the deputy that he'd done 4 lines of heroin the night before. 2 other victims, Keith Thompson and David Decker. Glidden also attempted to take extra money from 2 elderly victims well after being charged with theft in the Beverly McGill case, and he was partially successful in doing that. Keith Thompson, age 81 at the time, would testify very strongly that on July 21st, 2021, Glidden had asked for an additional $2,000 in addition to the $5,500 already provided for a down payment on a roof to use to resolve his problems with Beverly and for bail. Glidden promised to get to Mr. Thompson's roof on July 28th, 2021 and deduct the $2,000 from the total bill. Mr. Thompson agreed with the condition that Glidden be on his roof, and those were not exactly his words, on the 28th. Glidden wrote out a promissory note which would be presented in evidence by the state, which indicated that Glidden would start Mr. Thompson's roof on July 28th. Mr. Thompson wrote the check to Glidden for $2,000. The check was cashed by Glidden, and Glidden never returned. David Decker, age 74, would testify that Glidden had asked him for an additional $400 to repair his truck transmission so he'd get to work on Mr. Decker's roof. Mr. Decker, who had already made $2,500 deposit, declined to give him more money. Finally, Brenda Barnum, who is not a senior citizen but is younger, is representative of several victim complaints in their future testimony regarding Glidden's estimates that he relied on to refuse return of funds. Barbara Barnum would testify that on June 12, 2021, Tony Glidden possessed an email to her a contract reportedly signed by her in which deposits non-refundable declaration was on that document. Based on this document, Glidden refused to return a deposit of $2,500 to Brenda upon her request. Brenda had requested an estimate for repairs to be done on her home. She received an electronic copy of the estimate. She paid via BMO a $2,500 deposit. After several delays and difficulties reaching Glidden, she demanded the deposit be refunded and sent a refund request through BMO. Glidden sent her a copy of the quote signed contract, which contained a separate page designating deposits as non-refundable. She told law enforcement she would testify that she'd never seen that page. The document was signed electronically with a purported signature, and she would testify that the name on the document was misspelled and was in a font from MS Word that she had never used. Other victims in the attachment A would say similar things. Multiple text messages and emails would show that she and Glidden engaged in a heated email conversation during which she told him she was not a bank, was not going to finance his business with interest-free loans. He responded, 10th person to try, 10th person to lose. All of the victims in attachment A would testify they were not aware of Glidden's financial problems, his undercapitalization of his business, the backlog of uncompleted work, his drug use, gambling issues, employee issues, material supply problems. Nor were they aware he would quickly liquidate the deposits, leaving nothing for materials. His advertisement and statements misled them. If they had been aware, they never would have hired him, let alone make their large deposits.
Thank you, counsel. All right, Mr. Glidden, having carefully listened to the recitation, is there at this time anything you dispute or wish to correct on the record, sir? Was all of that information provided to you, Attorney Milton, in discovery? All right. Mr. Glidden, do you believe that if you had gone to trial, you would have been found guilty, sir?
Yes, ma'am.
Do you understand that if I accept your plea this morning, you are going to have a felony conviction on your record, Mr. Glidden?
Yes, ma'am.
As a felon, do you understand that you will never again have the right to use or possess a firearm at any time and for any reason, sir?
Yes, ma'am.
Do you understand that with this conviction on your record as a felony, if you are to commit any future crimes, that the punishment or sentence you receive for those crimes very well may be harsher or enhanced due to the fact that you have this felony conviction on your record?
Yes, ma'am.
And have you had enough time to work with your lawyer in order to understand what other collateral consequences
Yes, ma'am.
might exist for purposes of being a felon, whether in Maine or in other states? All right, have you understood everything that I've asked you this morning, Mr. Glidden?
Yes, ma'am.
Keeping everything in mind that I've asked you, do you still wish to enter a plea of guilty to the single count of theft by deception?
I do, ma'am.
And have you been truthful in your responses to me this morning?
Yes, ma'am.
Attorney Milton, are you satisfied that the defendant in this case is entering a guilty plea knowingly and voluntarily?
I am.
Based upon Mr. Glidden's answers to my questions this morning, I am satisfied that you are entering the plea of guilty to this significant felony offense and that you are doing so knowingly and voluntarily, sir. Similarly, based upon the comprehensive recitation of the expected evidence of this case gone to trial, I am certainly satisfied the state of Maine could prove each and every element of this offense beyond a reasonable doubt. So I'm accepting your plea to this felony offense this morning. Mr. Glidden, this is a serious set of circumstances for you. We are going to be setting this out for a sentencing hearing so that I can hear from the affected victims. And it sounds like they were very much affected by your scheme to prey on some of the most vulnerable people in our society. And the theft itself is an incredible amount of money. I can only imagine what it must feel like at this point in time to have your life's savings potentially stolen out from under you based upon such a scheme. So we will set this out and we will hear from those victims and we will hear how it has affected their lives, their finances, and their ability to trust people, I would assume as well. As far as a sentencing date is concerned, I suspect we'll need a fairly significant period of time allocated to this so that we can hear from everybody who wishes to be heard, who's affected. And so we will be sending out notice of that time for the sentencing at this point. And we will likely schedule it for, sounds like either an entire morning or an entire afternoon, depending on.
If you could help me notice, we do have some victims that are out of state, and we're gonna have to be generally contact them all by email, and so they'll need some contact information.
30 days or less.
I think we're talking about the week of August 22nd, which is completely free for me, and I had kind of indicated to them during an email that it might be in that number. So if we could, and we would also need a Zoom link, and I believe that some may be submitting letters as opposed to being in person.
Okay. All right. Do you want to be heard on the scheduling issues, Milton?
No, Your Honor, I had called the clerk's office, and that's how we found out
else you would like to put on the record, Attorney Milton, with regards to the plea this morning? Anything else, counsel? All right, that's going to conclude the Rule 11 for you, Mr. Glidden. We will be back for sentencing later in the summer. With that, the court will be in recess and off the record. We'll take up the matter of Mr. White in short order.